Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Video number 1529. We are going to discuss the observation of the Honorable Supreme Court of India, 3 judges bench, CJ A.S. Bopanna and Madam Hima Kohli. They observed that, no doubt, the public interest litigation is focused at the alleviation of the conditions of the citizens. Upashamanu, alleviation means. But heavy number of or thousands of frivolous public interest litigations, they are causing burden on the courts. Maybe the High Court, maybe the Supreme Court. So this is the main observation. You may be knowing, during the year 1980s or so, the then Justice P.N. Bhagavati, he has propounded the concept of public interest litigation, which is an exception to the locus standi principle. Anybody in the interest of public can send a private public interest litigation. Now, after almost about 70 years, in 1980, maybe 20 plus 1, okay, around 40 years let us take. After 40 years, now the courts are overburdened with the frivolous public interest litigations. During the COVID time also, the so-called our Solicitor General, I think, Mukul Rohatgi, he has clearly stated that let them stop the so-called public interest litigation factories. So, such is the grievance regarding the public interest litigations. Let them stop in relation to Prashant Bhushan, I believe. Right. Yesterday, that is on 28th February 2022, while disposing the case of Esteem Properties Private Limited versus Chetan Kamble in civil appeal number 10,425 by 2010. You can see the citation in Live Law 2022 SC 226. Honorable CJ and others, public interest litigation, definitely they alleviated the conditions of the citizens, but due to the influx of thousands of frivolous petitions, so definitely the courts are feeling burden, right? So this was decided in the above case. Of course, you have to read another case together with the same properties, Eastern properties. That is Coral Gonzalez and others versus Chetan Kamble. Right. Now, if you go to the facts of the case, it will be easy for you to understand. So, Mr. Gonzalez family, they have got certain properties in Kurla of Mumbai city itself. Please remember. A dispute arose between Gonzalez family and actually the state of Maharashtra. And actually Gonzalez properties were succeeded by Esteem properties. So Esteem properties are Gonzalez properties. Both of them come under the same footing and they fought against Chetan Kamble. Right. So if we go to the actual background of the story, it is like this. This land is located in survey number or CTS, they will city service number, CTS number 229 to an extent of 5 acres 20 guntas. Right. The East India Company during the year 1894, that is on 12/3/1994, they made a grant to Khoth of Kurla, and actually in the year 1984 there was an exchange of the deed to Gonzalez family. Right. But during the year 1953, the state of Maharashtra declared that this property, this land belongs to the state. So Gonzalez and others, they approached the Maharashtra Revenue Minister. So in 1995, Revenue Minister held that no, this property belongs to Gonzalez. So he has given a status quo order. But later the High Court, maybe in the year 1998 or so, 17/3/98, High Court all held that this property belongs to Chetan Kamble. because of another minister's order, I believe, whatever it is. So ultimately, High Court has declared that this property belongs to Maharashtra state, right? At the initial stage, they declared that it belongs to Gonzalez. Later, Maharashtra state minister has given some that is some restraining order. Ultimately, now the High Court declared that the subject matter is evidently belonging to the state of Maharashtra. Once again, Gonzalez went against. So by this time, Gonzalez family property was taken over by the so-called Eastern Properties, and the other state of Maharashtra, it has allotted the land to Chetan Kamble. Now the dispute has come between the Eastern Properties and Chetan Kamble. So background story, please know, background is only Gonzalez family versus state of Maharashtra. Right. Here now, the Bombay High Court allowed the writ petition, and they clearly stated that this belongs to the property. Then they went to division bench. Division bench once again said that this land belongs to. Actually, the division bench has not given a hearing to Gonzalez, stating that, "Array, how can you file a writ petition in the court? The matter is between private party and the state. So you have to file a civil suit against the state. This writ should not be filed in the shape of so-called public interest litigation." What is the public interest litigation? It is only private litigation, dispute between Gonzalez family and the state of Maharashtra or Chetan Kamble. So evidently, when a matter is a private litigation, how can you file the public interest litigation petition? This is the contention of the division bench of the so-called Bombay Court. Now the matter has come to the Supreme Court because Gonzalez was not given a fair hearing in the division bench. Therefore, they approached the Supreme Court. Please remember. So now, Honorable Supreme Court of India held that public interest litigation is nothing but, please remember, is nothing but a new concept which is aimed at the alleviation of the conditions of the citizens. Right. Now, but the situation has come to a mature stage because many claims, innovative claims, false claims, exaggerated claims, they are coming and they are burdening the courts. No doubt, even though the pill litigation has a beneficial effect on the Indian jurisprudence, but it has the deleterious effect of so-called burdening the court. Now it has become, the pill has become an abuse of the process of law. Ultimately, Supreme Court said that private interest should not be masqueraded as genuine claims. So ultimately, now giving a chance to Gonzalez to vent out his grievances, Supreme Court has disposed of the matter, stating that High Court has to give a chance to Gonzalez to represent his matter. So that is one part. As far as present topic is concerned, please remember, even though you are filing public interest litigations under Article 32 and 226 of the Constitution of India, of course, is an exception to locus standi, but court should be cautious because court has only limited powers in entertaining the pill. So court may decline. Please remember, court may decline if there is reasonable iota of suspicion. Then they need not take up the public interest. They need not number also, right? So ultimately, Supreme Court has clearly stated that public interest litigation should be for the interest of the public, not private interest. If there is a private interest, they have to file a civil suit, not pill. So this is the crux of the case law. Please remember, it is a very good judgment. Please read it and enrich your legal knowledge. Thank you very much.